Good evening. Thank you all for joining us remotely. My name is Lee Kelleher. I'm a barrister at 42 and I practice in private law and financial remedies. My colleague Jennifer Youngs in chambers with me practice in public law and private law work. This is our second webinar, the private law series. Hopefully if you want to register for the third series or episode, you can do so at the end of this webinar. And what we've done is helpfully put a question and answer box, which hopefully we'll try and pick up as we go along. But if there's not enough time to deal with them, of course, we'll have our email addresses at the end and we'll do our best to address those. And as always, following these webinars, there will be an email containing the recording and some feedback form, which will be gratefully received by us so we can try and improve our efforts to give some more further training to our colleagues. And of course, it'll be circulated on YouTube. This talk, as is entitled, you can see is Covert Recordings. It's hopefully a practical guide to some of the things we all come across and may come across in the future, particularly within private law. I've started this webinar in a way very much how remote hearings start, with there's warnings to clients who record proceedings and disseminate them on the internet. There's a case here which you can see whereby it's a clear and stark warning that it's not to be done, and there's some serious consequences and up to 4 months in prison this client received. It's a good case to read and to consider, and as a good guidance to remind our clients, if they are remote hearings, which they have been and continue to be, not to record, and to remind them that there are very serious consequences for doing so. It leads on really to what is a covert recording. As you can see on the screen, it is any recording made without express knowledge or permission, whether that's video or audio. With everybody now having a smartphone effectively in their pockets, it's not hard to envisage how easy it is to do covert recordings in pretty much any setting. This webinar will try to cover as best as possible the three main areas, which are recordings of professionals, which are CAFCAS, experts, social workers, for example, children, which is self-explanatory, and then family members in particular, focus on partners and husbands and wives in particular, where they are able to access them day-to-day in intimate environments, and of course be able to record them in doing so. There is guidance. There's a very brief page. I've put it there simply for those when this webinar is released later on with the slides to reflect upon this guidance. It is an important document. It is from the Family Justice Council draft guidance. We've tried to lift some of the key features from that report in this webinar, but if you haven't read it already, I would strongly encourage those haven't to read it, reflect upon it, because it signposts to some useful information if you are faced with a client who is either seeking to do covert recordings or has, or you're faced with an opposition who is raising it as an issue within proceedings.
Yeah, and as Lee said, we try to sort of draw out some of those main headings from the guidance for the purpose of this webinar today. One thing that guidance does deal with is whether, aside from its use within family proceedings, recording in the circumstances that we've just set out would be lawful. The recording by public bodies is addressed within that guidance, and that is probably implicated more heavily in public law proceedings, which we're not dealing with today. But certainly there is reference within that to Article 8. That doesn't seem to apply when the recording is between family members within the private law context, because the duty isn't of the state in that scenario. But there does appear to be relevance to GDPR. The court hasn't, or the courts haven't given a clear and determinative view on that point. But in the case of M&F, which is currently on the screen, it was subject to comment where it says that it doesn't appear to be subject to any of the exemptions. So that's something that also should be considered when you are discussing this kind of thing with clients. And then some other things to think about specifically within the family context are whether or not is a criminal offence in particular, there is, of course, a scenario in which, in the family context, there have been allegations by one party as against another, and those allegations may be of, for example, coercive and controlling behaviour or harassment. Both of those are obviously criminal in their nature if the criminal offence is made out, and therefore that is something that parties should remain mindful of if they are considering recording, or if they're considering adducing those recordings into family proceedings. There is, of course, the potential for there to then be further publication beyond the family proceedings in issue, for example, on TikTok or similar, and that again may be considered by a court, whether a criminal or a family court, to be conduct which is considered harassing in its nature or coercive, and the court will, of course, have to consider all of those issues when it's considering decisions relating to children. And I'm sure everyone watching will be more than familiar with PD 12J and the guidance contained within that. I've also just noted on that slide there as well that it's potentially, if there is a non-molestation order in place, if that non-molestation order contains provisions as to not harass or similar the other party, it may also be breach of that as well. So turning then to situations in which individuals, realistically in this context, clients might undertake covert recordings. And we've set out some reasons there. For example, they may not trust professionals such as CAFCAS officers who are undertaking work within the proceedings. They may not trust the other parent's account of what is being said, and they might consider that recording those conversations is the way to prove their own case. The recording might be for evidence gathering in the sense that it's actually something that happened prior to proceedings and they have recorded an argument or similar, or they might be trying to gather evidence within proceedings, and that is often in the nature of recording contact handovers, recording a child, and things of that nature. And similar to that, the evidence may be being adduced to prove or disprove allegations made by the other party, or to dispute what is being said by professionals. There are a number of scenarios in which that last provision might apply in respect to professionals. It might be, as I've already said, the CAFCAS officer. Of course, there might be local authority social workers involved, and there may also be court instructed experts whom the parent may wish to record their interaction with, and that's dealt with in a specific case, which we will turn to now.
Thank you very much. It leads on to, as we've indicated earlier, one of the common issues in the recording is relating to professionals. Of course, you can see the quote on the screen in relation to CAFCAS, and indicating that they shouldn't have anything to fear. And the reason being is they're meant to be working to a professional standard on behalf of the child, should be able to defend what they say in any assessment with the parents. But of course, we'll come on to due course about some concerns which might arise in terms of recording professionals. But in principle, you can see CAFCAS's view there. It's important when considering recording professionals. Of course, I've been in situations where it's caused me some concern where a client said they want to do it or they've done it, as to why they've done it. But really, there's some important cases where without it, without recording professionals, it's really shown examples of professional malpractice. It's only been established, as you can see in the case of Reby, by covert recording that individual. And that's important to bear in mind. There's not a blanket no. There are considerations to think about, and covert recordings have assisted within cases, as you can see. REF, as you can see on the screen there, was another example of there being a significant discrepancy between the notes of an expert and the covert recording. And actually the court found that what was said in the report was actually misquoted or misrepresented by that client. So you can see the importance of a covert recording in that regard. And then Medway, the 2015 case, this was the local authority seeking to rely upon allegations by a foster parent, or alleging that the mother had acted inappropriately. Unbeknown to her, the mother had recorded the foster parent, who was found to have been racially abusive and quite hostile to the mother. And then when it came to final hearing, it came to light, the credibility of the foster parent was dismissed, because of the things said and done, highlighted by the covert recordings. You can see, of course, some concern raised by the British Psychological Society at the bottom, that it can be, in their view, considered inappropriate and could affect ability of any assessment of a parent. So there's concern, there's caution that needs to be taken in relation to this. And there has been some debate, actually, whether within the family court they should be more open in terms of overt recordings as opposed to covert, because that might help rebuild some trust and understand, and everybody understands the position they're in, and they're being knowingly being recorded, as opposed to potentially impacting the assessment. It considers then the next question, what to advise clients in terms of recording professionals. And as I've said, it is a concern. It can cause alarm bells if a client raises it with you, but there are different circumstances in which a client might discuss it with you. It might be they are intending to record Kafkas, for example, and that advice is very different to considering they have recorded them, because then ethical points come into play, having to listen to the recordings. But always, we would say, is be upfront with clients. If they are saying they want to do it, advise them on the risks, which we'll highlight in due course, highlight how it might be perceived by the courts, and highlight, of course, that it affects trust as well, potentially, between professionals and parents, and just really having the full picture so they understand if they do proceed on that basis, or they have done it, that they're fully armed with the consequences that may arise from it, and then they can make that decision for themselves. What I have indicated as well, and something we might discuss in a moment, is if they've already done the recording, what you can do, what you should do, some signposts, as I said, about ethical points, but it's something we'll discuss between ourselves and share with you in a few moments' time.
I think also just on that point about so what to advise, the thrust of the Kafkas guidance appears to be a focus on being open and honest with the court and also with the people with whom they are working. And there is also reference in the guidance to, if the interview is recorded, that being recorded in the safeguarding letter, for example. It does therefore appear that the focus of that Kafkas guidance may in fact be recordings where that Kafkas officer is aware. And certainly on the basis of that guidance, there doesn't appear to be any reticence to overt recordings. And certainly when there have been debates, for example, at the Family Justice Council, there has been discussion as to whether or not overt recording should be more widely used to ensure that everyone knows that what is being said will be recorded. And therefore, again, that may be something to discuss with clients, is that if they want to, for example, record their safeguarding interview, that they discuss that with the Kafkas officer, so it's not something that arises at a later date. Moving on then to why parents might record each other. I think I actually already dealt with that in some detail in an earlier slide as to what evidential value those recordings might have. And so therefore I won't dwell on that one any further. Thinking then about in the context where one parent has recorded another, I've already dealt with how the court might view that conduct itself as relevant to the determination of welfare. And this case of HKS and HSM from 2021 deals with that specific point. This essentially the court deemed to be a father conducting surveillance of a mother within proceedings. He had said he was conducting that surveillance because he was concerned about the mother's mental health and or he believed the mother to be plotting against him. However, the court determined that had in fact been a substantial invasion of mother's privacy, unsurprisingly causing her anxiety and distress. And the fact of those recordings was considered by the trial judge. So therefore, it's not just the content that's going to be relevant to welfare, but the very fact that the recording has taken place is a factor that will need to be considered in these type of cases. The Family Justice Council guidance sets out that, as I've already referenced, that there will be profound consequences for the welfare of any child subjected by a parent to such a degree of invasion of privacy when that child themselves are the ones being recorded. the case of M&F, to which I've already referred, was a case in which one parent had sewn a recording device onto the child to film that child's interaction with a social worker. And Mr. Justice Jackson stated within that case that it's almost always likely to be wrong for a recording device to be placed on a child for the purpose of gathering evidence in family proceedings, whether or not the child is aware of its presence. And therefore that again, the very fact that that recording had been attempted and had been undertaken was a matter that was relevant to welfare. And one other matter that is also raised in the case law is the parents' insight then into that impact on the welfare will also be relevant. As if, for example, the parent does not accept the adverse impact that could have on the child, that will be relevant to a court's assessment of their case.
Thank you. So I indicated earlier in terms of some practical considerations about what happens if you are presented with a scenario of covert recordings, and sometimes it can matter whether it's inside or outside proceedings, because your advice can be quite different in relation to that. If it's outside proceedings, you have to consider first that it may be appropriate for you to listen to those recordings, but of course you need to be upfront with the client that it might be a situation whereby it doesn't paint them in a great light. There are considerations that you might have to advise them that they must disclose those recordings, and then ethical considerations if your client then doesn't accept your advice. So it's really important from your own individual perspective as well to consider what impact it has on you as well, acting for that client before you embark upon listening to recordings. Be upfront with the client, be clear they are ethical points, be clear about the risks that can be perceived in terms of recordings. It might not actually show, which we'll discuss in a moment, the picture they're trying to paint, and actually could backfire on them. Give them the complete overview, give them the picture that they can assess what is right for them. I've indicated as well, inside proceedings is slightly different. Of course, you are now under the scope of the court. It's generally, as we'll come on to, as case management. It needs to be flagged with the court if the client is insistent on relying upon it, or your advice is to disclose it. And we've put at the bottom of the slide there, we've both, I think, been in situations where the advice from CAFCAS is them not to listen to recordings without the say-so of the court. I've been in situations whereby they have done so, and obviously there's been an impact then perhaps on safeguarding or recommendations. So this needs to be flagged with the court as well, and to consider what management that needs to be addressed in terms of that issue potentially as well. But one of the things that has been highlighted in debates and discussions is when the clients are using covert recordings, it unfortunately shows a lack of trust within the system, because if the clients had faith within the system to do them justice, they wouldn't seek to try and record professionals, for example. So it highlights a little bit of a disconnect between clients and the family courts. But as I say, it also comes back to being very clear in your advice to the clients, what is sought to be achieved by that, and what the role of the court is in relation to recordings.
And I think one of the things that has been suggested in the course of, again, that same Family Justice Council debate is that some reassurance of how the process works and what evidence will be adduced might assist. That perhaps may be a slightly optimistic view in terms of reassuring people going through an incredibly stressful process as to what the court will consider when making its decisions. But certainly that is a conversation worth having at the same time. It's also noting, of course, that if it is not your client that has taken the recording, but CAFCAS have viewed it, and that has had has caused a negative view to be formed about your client, it is worth referring back to the guidance that says that, in fact, CAFCAS should wait for the court's adjudication on that issue. Moving then to the procedural requirements, if you are seeking to adduce a recording that has been made, hearsay won't go into admissibility, but it will go to weight. The Family Justice Council guidance suggests that the matters set out in Section 4 of the Civil Evidence Act 1995 are considered, and I won't go through all of those as those are in the guidance. The case of Re B sets out that it is not expected that an application would need to be made before that evidence could be relied upon. that evidence can be adduced. However, having said that, there are a number of procedural considerations which we will come on to because of the nature of that evidence, and it being such that actually simply adducing it is unlikely to be sufficient for the court's purposes of analysing that evidence. But in law, a party does not require permission to rely upon that recording. The case law does then go on to address what to do, for example, if you do seek to rely on that evidence. And as I say, I think that's dealt with in a later slide, but matters such as obtaining a transcript and the like. We've then gone on to set out the relevant provisions of the family procedure rules which deal with the admission of evidence for reference there.
We've briefly touched upon a case, the REM 2022 case, which deals with intimate images. It's a relevant point because it is a recording, and both parties in that situation were trying to rely upon recordings. It's an important case to look at, consider, of course, what the courts has to in terms of recordings of that nature, any emotional, psychological harm which may be caused to the parties if that recording is then adduced in court and relied upon. We don't intend to discuss that case in detail. It was just as a flag because it felt like it came under the umbrella of the covert recordings, and you might find yourself in a situation where, in some cases, this does come as an issue, and this is a very good case to signpost yourself to consider the impacts of it. But of course, the things you have to consider when advising the client, if you are to rely upon those allegations and those images, what you need to do to cross-check with.
And again, it goes to the issue of the very fact that things like this have been adduced may not always be in the person adducing them's favour. The next slide deals with the issue of specifically relying on evidence of a child having been recorded. The law may be different will be different if the court considers that it's an assessment under Section 13 of the Children and Families Act, and it's admissible until the time rules it admissible. The broader issues in respect to recording a child are that, for example, the court will not know if that child has been coached prior to the recording being undertaken. And when we deal with broader case management issues in respect of recordings, it's noted, for example, that no one knows what's said before a recording starts. No one knows what's happening off camera, particularly if that is simply an audio recording. And also, if the purpose of a recording is to obtain a child's evidence as to something they say has or has not happened, a party would risk undermining any ongoing police investigation, for example, if there is due to be an achieving best evidence interview and the like. So those are also issues that need to be considered, and realistically a court is likely to be concerned if that is an exercise that is being undertaken within private law proceedings.
This leads on to what I'd indicated earlier in terms of case management. You can see in your screen there a bit of a shopping list of terms of things to consider. They are not exhaustive, but things to flag to yourself or to the client when faced with this issue, because you have to consider, as I've indicated, when was the recording made, in what circumstances. We've been in, I'm sure most of us have been involved in situations where there's an argument run whereby it's a fabricated or created incident for a covert recording to try and draw out information. So think about that. Who made the recording? What was the motive behind it? Are they authentic? And requests then to consider whether you need the full transcript, the full phone, if it's recorded on a phone. How was it obtained? If it was illegally obtained, it doesn't per se mean it's not admissible. It comes down to weight. And then costs considerations of all these things. Is a hearing needed to consider all of these points over and above a normal case management hearing? The cost of that, the cost of a transcript, cost possibly of experts being involved of looking at phones. And then when these sorts of issues come to light, and depending what the recording shows, I've been involved in cases where courts are asking then whether a guardian needs to be appointed. That then prolongs proceedings, introduces an additional party, and further complicates matters. It's not to say clients shouldn't rely on covert recordings, they shouldn't seek court's guidance, but they should be fully informed as to what sort of things need to be considered when they come to case management, because a lot of it adds to costs. But of course, in and above that, we've mentioned ourselves, there's trust as well that goes to that as well, whether really it's worth it, bringing this to the attention that the client wants to raise it. And of course, if the child is recorded, there's a question mark then as to whether the child needs to give evidence and then re-W application. So there's a very complicated umbrella that comes from covert recordings. And as we say, clients should know what sort of things, as we put on the screen, a judge might consider, the cost consequences of it. And as always, we say caution about the risks and consequences of relying upon those recordings.
This slide then deals with the weight that is attached to any recording that is made. I've already addressed some of those points, as has Lee, when he was dealing with case management. But again, much of this goes to what was the purpose of that recording? Did the person doing the recording conceal, or did they have the ability to conceal or misrepresent matters? Was it just an audio recording? Was the original edited? And that may, of course, require expert evidence, as already referenced. There is a case which is REA from 2021, which may not be on the slide, or we'll make sure it is when the PowerPoint is sent round, which deals with the issue of the person taking the recording has the ability and is in control of the situation, has the ability to present that in the way that they want it to be perceived. And in that case, Mr. Justice Poole refused an application to admit evidence of covert recordings that had been taken of video contact with a child, where the child was unaware the contact session was being recorded. And he said that he dismissed that application because they had been made covertly, and the father had sole control over what was recorded and could have steered recorded conversations with his child to suit his purposes. Hence, the evidence would be of very little weight. Having looked at the family procedure rules earlier in this presentation, it may in fact be that it was actually an application to exclude that, but in any event, the court certainly didn't allow the father to rely on it in those circumstances.
Just to pop back slightly to that. When Jennifer and I were discussing this topic in terms of covert recordings, we were trying to discuss kind of some examples we've come across within our own practices in terms of how recordings have been perceived by the court. And three stick out to me in particular. I thought I'd share them just to kind of give an overview, perhaps, as sometimes they don't always show the picture that the client wants. I had one particular client who placed a mobile phone at the top of the stairs, waiting for the father to enter into the property, and then encouraged the child to say to father, do you remember when you did X, Y, and Z, in terms of shouting or slapping or doing sorts of things? And I was presented with that at the fact-find hearing. My client was very clear that she thought that helped her case. I was very worried about it, and the judge actually found that it said a lot more about the mother than they did the father in that situation, dragging the children into the situation, trying to orchestrate evidence to assist her case. And a similar example as well, quite recently, on a different level, was handover, where a client was trying to show handovers were really good for him. The children were willing and happy to go and laugh and excited. But then on return, he had recorded the children being upset and expressing that they don't want to go. And one of the observations of the trial judge was that she was concerned because that showed that father was trying to build a picture that he was a better parent than the mother, the children wanted to remain with him, and in fact questioned why, if the children were expressing upset, why he didn't put his phone down and simply trying to help his children go more easily to the mother. But on the flip side, there's been involved in cases of fact find where recordings, covert, have really demonstrated abusive behaviour of a particular party with swearing and how they're acting in the property. It's just to show an example of those three. It's not always as the client thinks in terms of code recordings. They are helpful to their case. They may perceive them to be helpful and they may perceive them to get the answers that they wanted, but it's sometimes viewed very differently by a judge in the case. So as I've said throughout, it is the degree of caution is needed when approaching this. There's
also perhaps a potential distinction to draw there, isn't there, between the creation of evidence during proceedings and also when it was successful, it was evidence that had been obtained prior to the proceeding starting. That perhaps is certainly from my experience as well, where covert recordings have been more useful within those proceedings is when it's abusive conduct that's happened in the past, and that recording has been used to establish that has happened, rather than this has been recorded in the proceedings to create evidence for it. So I think that's perhaps an interesting distinction to draw.
Okay. It leads on to possible consequences, and we've highlighted some very briefly there, and we've indicated earlier increased costs potentially is a factor to consider for any privately paying client. Civil action is potentially unlawful in light of data protection, and risk of injunctive proceedings as well, whether this amounts then to behaviour that is unwanted, whether it's molestation, to consider that when parties are separated. But of course, what we're going to need parents in particular remember, as I've indicated earlier, is a breach of trust between the parents as well. Whatever happens within proceedings, and they can be hostile and a lot of conflict, often they are going to be co-parent in the children or child following proceedings. And there's a lot to be said that if there's a lot of recordings within proceedings, what that does to the relationship between mum and dad in particular, and whether or not that is beneficial to the long-term relationship they have to have together to work together with the children. But of course, it does have potentially an impact on the relationship with a child, which is what I've considered next. This comes from the guidance. It's the views of young people and how they were asked, how they received covert recordings. Some actually reported that say it was them being heard. So being covert recorded was actually them being heard, their voices being heard, what happened truly in the home. Some actually, conversely, said feelings of betrayal and discomfort, knowing that their caregiver was recorded them without their permission and was then using it in court, potentially to try and better themselves in the case, but of concern then about manipulating evidence or manipulating them into saying sorts of things. And there's a worry then children had in particular that what they said in a covert recording, however long it may be, 10 seconds or a minute, for example, whether it was taken out of context, had a parent edited that evidence, and they were worried about it in particular. And it shows really there's a wide perception of how particularly children can receive covert recordings, and they were also, and it's risky, they were also asked in terms of overt recordings, and they felt they were a little bit more positive knowing they were to be recorded, but also recognise the impact on their interactions, and their presentation might not be as genuine had it been if they didn't know. And it just shows the wide spectrum of being careful with recordings, particularly being very careful with children, and my colleague has discussed in terms of recording children. But it's important, I think, if you can read the guidance, the views of the young people is helpful, and I think it would be helpful for clients who are quite insistent on using recordings. They understand some potentially the impact it can have on their relationship with their children.
Great. So I've had a look, and I don't think anyone has sent us any questions as yet. That does conclude our presentation today, but if you do have any questions that arise subsequent to this presentation, do let us know on the email addresses which are set out there. I think all that therefore there is left to do is to say thank you for attending this webinar today. The recording will be available shortly, and that will be sent out as soon as that is available. And finally, the next webinar in the series will be on Thursday, the 4th of April, again at 5 p.m, which will be by Sian Smith and Catherine Howells, who are providing a general update as to private law children. So thank you again for attending.
Thank you.